Today on the Silver Solutions Radio Show, we're joined by Linda Strohschein, an elder law and estate planning attorney with the Strohschein Law Group.
Good morning, everyone. Welcome to Silver Solutions Radio, your show for living long and aging strong. Hey, we got something very exciting for you today. So we're being videotaped here on the Eldercare channel. And if you want to see us live after the show, okay, just go to this website, napervilleseniorcare.com. We're bringing this show to you because we're passionate about helping people, especially seniors and the disabled. I'm Jim Wojciechowski, and I'm joined here by my co-hosts, Jeanette Palmer and Kathy Wetters. We encourage you to call in with any questions during the show. Our guest is sitting right here, ready to answer your questions. Call us at 847-931-1410. That's 847-931-1410.
Our show is brought to you by Right at Home, your choice in senior care. It's broad, and it comes to choosing the right care for a loved one. The choice is narrow, right at home. Our mission is to provide, and it's to improve the quality of life for those we serve, and we do that by providing the right people to care for your loved ones. Make the right choice. Call Right at Home today. 877-ELDER-99. 877-353-3799.
Our guest today is Linda Strohschein from Strohschein Law Group. Welcome back, Linda.
Thank you very much.
Hi.
Thank you for having me.
The last time you were here, you were wearing your other hat with Trinity Advocacy Group.
Yep.
Yeah, you and
Yes, I
colleagues
was.
were here, yeah.
I lead a double life.
Yes, you do. Yes.
I think a lot of us do.
First, maybe the best approach would be to tell us kind of an overview of your law practice.
Okay. So I've been a lawyer for about 20 years now, and started my own practice about 12 years ago. Mm-hmm. And mine is a boutique estate planning and elder law firm. And so what that means is on the estate planning side, we do a lot of wills and trusts and powers of attorney where we're helping families to get prepared and to have their documents ready for when they need them. And on the elder law side of things, we're helping families when there's a long-term care crisis. And so we might be looking ahead. Maybe the crisis hasn't happened yet and we're planning ahead. Or maybe a loved one is on the doorstep of the nursing home and it's really time to start taking some steps to protect those assets, because we can absolutely do things at that point.
So, like if there was a life event like a serious health diagnosis of a degenerative disease, that would be maybe a good time to make sure everything's squared up there?
Well, it is a good time to take a look at what your options are. Certainly that's a very trying time for the family.
Yeah.
But what people in the community don't know about elder law is that there are a lot of very legitimate planning methods that we can use to help protect the senior's assets. Even when we're looking at paying several $1,000s a month for care, whether it's in-home care with Right at Home or it's in a facility, we can really look at options for protecting some of their assets. Now, I would say when the adult children come in and say, it's time to protect mom and dad's assets because we need an inheritance, that's one thing, versus the parents who are saying, we've really wanted to try to do something here, so what are our options?
Sure.
Excellent. So what is the difference between law and elder law?
Okay, that's a good question. So generally different areas of the law are based on, for example, DUI law. You're dealing with someone who's broken the law and dealing with the criminal system. Divorce law is dealing with families when they're separating. With elder law, it's not a very specific area, but it's the client that we serve. So that client is typically, in the elder law side, typically in the 65 to 85 range, where at that point, they're experiencing some higher level of care need. There's some issues there where we need to address, so it's more the client. It could be housing, it could be with Social Security benefits, it could be with veterans benefits. So it's not specific to the practice, it's the client that we serve. So that's the difference.
Oh, okay.
And so do you need special training to be an elder law attorney?
You don't necessarily need special training, although I am a certified elder law attorney, and that's shortened as a CELA. Almost sounds like SEAL, but it's not. The certified elder law attorney is some additional certification training I've taken to set myself apart, because this is something I do every day of the week. It's not just something I dabble in. And there's only about 10 of us in the state of Illinois.
And
Only
just the
10.
fact that that's what
Are you
your
kidding me?
criteria
No, I'm not.
is, that
There's a lot
your
of
focus.
there's a lot of seniors out there.
Right. There are a lot of seniors out there. So look for a certified elder law attorney. It really makes a difference.
I can imagine. If you're specialized in that type of training. Are you a fiduciary for the?
A fiduciary.
Okay.
No, not necessarily.
Okay.
So a fiduciary would be someone who's acting as an agent under a power of attorney, an executor under a will, a trustee under a trust. Those are the types of roles that a fiduciary might encounter. As the attorney, I am guiding that fiduciary. I'm making sure
Got it.
that they're following the rules. You know, if it's a trustee under a trust, they have to follow all the rules within the trust. And so my job, part of my job, is to guide them and make sure that that they're following those rules.
Now, when creating an estate plan, are there certain documents you recommend be included with that plan for all of your clients?
Well, I do. There are attorneys out there who say that everybody needs a will, everybody needs a trust, and while I agree that most people will benefit from those documents, I really don't think everyone needs them.
Okay.
What I do think everyone needs, really anyone over the age of 18, is two things. Three. Power of attorney for health care, a power of attorney for property, and then also a HIPAA release. So those three documents are, in my opinion, mandatory for anyone over the age of 18. Because what those documents do is they allow you to name someone as your decision maker if ever there's a time when you can't make or communicate your own decisions. So power of attorney for healthcare, you're allowing someone to step in and make medical decisions for you if you can't make your own decisions.
Right.
Whether that's temporary or a permanent situation.
Right.
And then also we have power of attorney for property, where a loved one or someone you trust can step into your shoes financially, maybe move assets around. If you're recovering in the hospital for a period of time and you can't get to the bank to move money from savings to checking to get the real estate taxes paid, your agent can step in and do that for you. So those are the most important things.
Excellent.
Aren't there free forms available on the internet for powers of attorney?
There are.
Okay.
The powers of attorney on the internet, you can do a search for Illinois statutory short form power of attorney for healthcare or property. I know that's a mouthful, but that's the title.
Okay.
I didn't make it up. And if the option is either skipping going to the attorney and not having them, or going online and getting them, absolutely. Go online, get the most recent statutory form. I think it was it changed last year? I'm not sure. There's been some recent changes. So at least a 2014 or 15 version of the document is going to be the most current.
Okay.
And so absolutely get those.
Okay.
Now, the documents that I'll provide in my office are going to be a little bit more detailed than what you're going to find in the basic form, especially in the power of attorney for property. We have a lot of extra paragraphs we add in just based on things that we've seen from our clients. But if the choice is to not get them or get them online, absolutely get them online. They're really very, very beneficial, because without those, we're probably going to have to go into guardianship court at some point, and we don't want to do that.
So it's the difference between driving like a Kia or a Buick.
Yeah. Or I was going to say maybe like a Kia and a Mercedes.
Well, I don't know.
There
We're
we
gonna
go.
with the Mercedes.
There we
Because
go.
sometimes not everyone can afford their Mercedes, but I feel like, upper middle class or middle class people drive the Buick,
Right.
So
All those
are
new
people-
commercials on TV.
Yeah, yeah. Or maybe the Lincoln with Matthew McConaughey.
Oh, there
Oh,
we
and those
go.
dogs
Yeah. So
who want
yeah,
barbecue.
try not to stereotype anyone.
Yeah.
Yeah.
No, it's important. I mean, these are legal documents, so I would think, being legal documents, it would be important to have an attorney look over them. Even if they pull them down, they do them. But you're so well trained in this that you'd be able to ask additional questions that they might not be able to, they don't even think
Right.
about. Okay.
So I get that question all the time. What can't I just go online? Can't I go to LegalZoom or search online and just pull up a will or a trust? And can't I do that myself? And the answer is yes, you can. Although, like you mentioned, because of my training, because of my almost 20 years of experience, this is what I do every day. So I do see issues. I had an example a couple of years ago where a gentleman I was working with was battling cancer. And I think at some point realized that he wasn't going to win. So he got a trust, and he even got a document called an assignment where you can assign your personal items or your finances to the trust. So it was a great step that he took. And the documents themselves were pretty decent. Maybe not as thorough as I would have liked, but they would have worked. Except for his plan to sign them didn't work as he had hoped. He signed one of the documents, and I forget which order, but let's say he signed the trust on Tuesday and the assignment on Thursday. And the assignment says, I'm going to assign everything to the trust I signed on Thursday. Except for he didn't sign it on Thursday, he signed it on Tuesday. So it was like the trust and the assignment went like ships passing in the night.
And I can see how important that would be, having they
Right.
have to be done in order.
Right. And so he was not married to the woman he was with. They'd been together for many years, but she came into our office after he passed away when she was starting to realize what the problem was. The assets were not connected to the trust. So we had to go into court. We had to ask permission from the judge, and we ended up getting it done, but it was a little bit more difficult. Had we, like Jim mentioned, had we taken a look at it ahead of time and we said, wait, let's re-sign them and get these to match.
Sure.
And it might have been a little bit easier. It would certainly have been a lot easier.
So let me give a different analogy because I'm still not good on the Kia Buick thing. So I'm thinking of more like how you were saying, like you go to a specialist, like an orthopedic surgeon, to have your hip done, because that's what they do every single day. And so, and they know all the latest techniques, they know, all of the, best practices. And so that's how you are, in the sense of you are a specialist in this type of law. And that's what the benefit is for the, clients to come to you versus just even like a family attorney or someone like that. I'm imagining like anyone can draw up these papers just like you can go online and pull, the documents offline. But it's so important for them to go to you because you are a specialist.
Correct. Although I'd have to say that the bar rules say I can't call myself a specialist.
Oh gosh.
Okay.
But I will tell you, you use the word, but I can't. I can tell you that I do this every day,
Right.
every day of the week. So
You're very well experienced.
if you
Right.
categorize me as a specialist, then that's okay.
Okay, thanks.
I just can't
Yeah,
say
try
that
not
myself.
to break the law.
That's okay.
Heaven forbid. And so, you mentioned about the HIPAA, and we deal with that all the time with our clients, and it's getting more and more important because of the laws associated with it. So can you explain a little bit more about that HIPAA?
Absolutely. So in the newer forms of the powers of attorney, both the healthcare and the property, there should be a HIPAA paragraph in there. I often encourage families that if they have documents that they've signed some years ago, go back and look at them. And while most people don't understand the full document, you can look and see, are those initials there, HIPAA? If it's there, you've got a HIPAA release. If it's not, you need a new form. So HIPAA is that privacy policy when you go to the doctor, you go to the hospital, and you want that medical provider to be able to speak with your family so that your family can make good decisions. So you need to have that HIPAA release in your powers of attorney. That's a great place to have it. But also, we usually recommend having a separate HIPAA release so that even if you're going to, there's an emergency and you're going to a different hospital than you normally would. Let's say you're out visiting your grandchildren or something in, a different part of the state or a different state altogether. If you have a general HIPAA release, then there's no concern about family members being able to get the medical information and being able to speak with the medical providers.
And so I'd like to, as a mother of an adult child now that's going off to college, I'd like you to speak to that because I don't think that people realize that because you're still the parent.
Yes.
You are still the
and you're
parent.
still paying those bills to go to
You are.
college.
But you have
now-
absolutely no right to access information for them. So
Wow.
you need to have, that's a good point. I'm glad you brought it up because we talk so much about our senior clients and how we need powers of attorney for them to help them. But the adult children who are now 18, you need to have your child needs to have a HIPAA release giving permission to you to speak with that medical provider.
Right.
And doesn't have to go with him or her to college. You can keep it where it's needed. But, when you know that your child's gone to the hospital or you need to speak with one of their medical providers, you can send a copy, be able to make that call, get the information you need. So we...
and the time is to do it is now and not in the case of an emergency.
Correct. Actually, the time to do it is right on their 18th birthday or before they go back to school.
Okay.
If they don't turn 18 until they've already gone away to college, then as soon as they come back, or perhaps get one of those internet forms in the meantime, but get it done.
Yeah.
Get it done.
And here's another good example. I'm sitting here thinking, and thank you for being here, because you just hit me upside of the head. My son's a fireman. I have two children, both not married, adult children. My son's a fireman, and he's a soldier. And my daughters, and neither one of them are married. I mean, if something should happen to them, who makes the decisions on that if they don't have this form in order?
Right.
Right. Again, the powers of attorney allow someone that you appoint, someone whom you trust, to step in and make those choices for you, during lifetime.
So what's some things you can do if, what happens if you don't have a form in place and you become unable, I can't talk all of a sudden, make decisions for yourself?
Well, that's the guardianship we mentioned briefly.
Okay.
So guardianship is when someone can't make their own decisions and there's no document in place like a power of attorney that would allow someone else to take over. So guardianship is typical in two situations. The child who is born with Down syndrome, once they turn 18, that child probably won't be able, even as an adult, won't be able to make good decisions.
Right.
They can certainly make some, but not good decisions in big issues. So parents probably need to go into guardianship court pretty close to when that child turns 18 so they can continue making decisions for their child.
Okay.
The other situation is what we typically think of as a guardianship, when grandma's been able to make her own decisions throughout her lifetime, but she had a stroke and now she can't communicate or she can't really make good decisions for other reasons. And if there is no power of attorney, again, there's no document in place to give that authorization to anyone, then we have to go into court to get that permission to make decisions for her.
So heaven forbid, if there's not the proper forms in place, an adult child has a car wreck and is in a coma or whatever, then you'd have to actually go to court to get a guardianship to make health care decisions.
Correct.
Correct. Okay.
Now there is the Healthcare Surrogate Act, which the hospital then can allow certain family members to make certain decisions, but in most cases it's not going to be enough. That might be enough to cover just the basic decisions there at the hospital, but once we leave the hospital, we're transferring to a rehab facility. You need someone with authorization to be able to sign the discharge papers, to be able to sign the contract at the new facility, or sign the contract with your company to bring in a care provider. So there's a lot of authority that needs to be created.
And do you ever run into a senior that maybe has control issues and just
Never.
fights this?
Really?
I'm sure you don't either, right?
No, we don't.
I'm sorry, the control issues about what?
Not wanting to have HIPAA releases signed and whatever. Do you ever run into that?
Absolutely. Yep, I deal with that every day. And so, we can only encourage so much and tell families, again, get them free online. They're a few $100s when you come to our office. Get these documents. But if someone really doesn't want to put those documents in place, then that's okay. I just actually had a situation, I met with a gentleman probably, I don't know, maybe late winter, early spring, and went over to the facility. He had capacity at that point. He was able to communicate with me and make good decisions. Well, actually making good decisions. He was just not making decisions, essentially.
Period.
He didn't want to. And his son was trying to help him, and Dad said, no, thanks anyways, but no, I'm good. As I understand, there's been some additional medical situations happening since then, and now we're being brought in to go into guardianship, and that's expensive.
Yes.
Guardianship and typically is about $5,000 for the first year. And those fees will continue throughout the period of guardianship. Maybe not to that extreme, And that's even in an uncontested guardianship.
Wow.
Even in uncontested.
Uncontested, right.
Wow.
So if another gentleman I was just talking to, we do have a contested guardianship, and there's going to be some fight about this, and that's the costs are going to go up. So that's why I really honestly want to avoid guardianship if we can. It's expensive for the family. It's time consuming. It can really tear a family apart if we've got people on different sides. It's so much easier to get the powers of attorney.
Yes, absolutely.
So
Yes.
much easier.
I understand that, yeah.
Yes. In fact, we covered some of the when a guardian is needed. Well, and before I ask the question, I'd like to encourage our audience to call us with any questions at 847-931-1410. That's 847-931-1410. Call in and ask Linda a question. But what are the responsibilities of a guardian? Can you dig into that a little bit more?
Sure. So a guardian, much like with the powers of attorney, where there's a power of attorney for health care and a power of attorney for property, there's a guardian of the person and a guardian of the estate. So the guardian of the person is the one who is in charge of making day-to-day decisions, medical decisions, placement decisions. If we're talking about a young adult with a disability, maybe we're talking about educational type of decisions. Guardian of the estate is the one who takes care of that person's money. So making sure that the facility or the care providers get paid, making sure the real estate taxes get paid if they're at home. Anything that needs to happen with the finances, making sure they're invested properly, things like that. So generally the guardian is in charge of making those types of decisions.
Excellent.
Okay.
And so, we had mentioned briefly before that you also have a company or are involved with care coordination. And so, can you explain to us a bit more about that and, how, how it's a benefit for the attorney to have a care coordination unit?
Sure. Okay. So because we deal with so many families who have long-term care issues for themselves or their loved ones, sometimes these issues are not legal in nature. I can deal with the legal and the financial. That's my job.
Sure.
But a lot of times families they've got questions about what the facility is doing, what they're supposed to be doing, what they're maybe not doing. And sometimes there's just advocacy issues that we need to tackle. And what we found some time ago is that as the lawyer, when I jump into that situation, now the facility gets their lawyer involved, and now we're going to court. And that's not the point.
Right.
The point is trying to advocate for good care for your loved one and not go into court.
Yes.
As a lawyer, I can do all those things if we need to. But my job in that situation is to advocate for good care for the client, not run into court. So we brought on a care coordinator some years ago, actually probably 5 or 6 years ago, where first we had a nurse in the office, which might sound odd to have an RN in the law office, but she wasn't taking blood pressure checks.
Right.
Right.
But she'd be out in the facility, and she would go talk to the facility providers and just ask good questions and advocate for good care and make sure things were taken care of the way they should be.
Excellent.
And help to work towards resolution if they aren't being taken care of the way they should be. And so initially I had an RN in the office, and then she retired, and now I have Colleen. She's a gerontologist. And so it really makes a big difference. She sits in on every long-term care planning meeting, that initial meeting where we're trying to figure out what does the family need? How can we help them?
And based on her experience and her specialty, she's able to give good advice because she has that
Absolutely.
experience.
Absolutely.
You know?
Families often come in and say, the hospital gave me a list 3 pages long of
Yeah.
different facilities, and they don't necessarily know what type of facility they're looking for.
Right.
Maybe we don't need rehab, maybe we need a supportive living. But our experience is that most folks don't know the difference between the types of facilities.
Right.
And
That's
you
our
guys know
experience,
there's a
too.
huge difference
Certainly
in
is.
all those, from independent living to supportive living. How supportive is different than assisted, memory care,
Memory
all
care
private
now,
pay, and then
exactly.
nursing home and skilled rehab. So lots and lots of options. That's a great part. There really are so many options. But families are confused about that because they don't know what they're looking for.
And
So
there are-
again, she can advocate for that.
It's a good example. We have a decorator coming into the house because there are so many options out there.
Right.
Okay, I mean, it is confusing. We go out shopping and it's just to decorate the house, and it is just totally confusing. So we
I think
brought
I
a
need your
decorator.
decorator.
Okay. So we got, but that's exactly what you're describing here is that the options are so great today, which is a great thing. But you need some guidance and help getting them what's going to be best for them.
Absolutely.
Yeah.
So what is involved in estate administration?
Okay. So that's after someone's passed away. If that person has a will, we're going to follow the instructions in the will. If that person has a trust, we're going to follow the instructions in the trust. If they don't have either of those documents, then they still have an estate plan and we still have to follow it. But that estate plan might include joint tenancy at the bank. It might include beneficiary designations on the life insurance or on the retirement accounts. And so families are often confused because they call the insurance company and the insurance company says, sorry, can't tell you anything, which maybe means that they're not the beneficiary, or maybe there is no beneficiary. So families get frustrated at some point and they say, oh, I think I need to go see the lawyer. So our job is really just to smooth out that process. Once someone's passed away, we need to collect their assets, we need to pay their bills, we need to make a distribution. And that process might involve probate or maybe it doesn't. Really just depends on a lot of different factors.
And there's a length of time, like, too, something about like the estate, if there are there's debt associated with it.
So when we open up a probate estate, we do have to notify the creditors, and that's actually a good thing, notifying the creditors. We have to give unknown creditors a maximum of 6 months notice. So once a loved one passes away, if we need to go into court, we start the court proceeding and then right away we publish notice in the newspaper for those unknown creditors. Because if we don't know who they are, we can't send them a letter.
What those were for. Yeah,
that's what it's for.
Okay.
So because if we don't know who they are, we can't send them a letter. Not going to be very effective. So we publish a notice in the newspaper and basically say, hey, anybody out there in the whole entire world, if you have a claim against this person's estate, you have 6 months to essentially get your butt in here and make your claim.
And how long do you have to post that, like from the time the person passes to put the ad in the paper?
There's no requirement as to how long from the time it starts to the time the publication starts, but we want to get that publication in sooner rather than later because we can't close until the publication starts and it runs for essentially 6 months. Okay. So that's why we often will say an estate will be open at a minimum probably about 7, 8, 9 months because from the day we open officially in the court system and then publish notice, then we have at least 6 months to get through. So there's just a little bit of time on the beginning to get the papers put together, a little bit of time on the end to get everything closed up. So that's going to be for the most part, the shortest estate is going to be about 8 or 9 months.
And so anyone that dies, do they have an estate? Like,
most people do of some sort. Again, we're looking at collecting the assets. We have to first of all figure out what that is, and then we have to identify if there's any beneficiaries. So if Grandpa passes away and he had a life insurance policy, that life insurance policy, I can't talk like you can, that life insurance policy probably named Grandma as his beneficiary. Maybe she's already passed away, so then we look at are the children on there. So we just have to figure out how is that asset going to be distributed.
I see.
And if there's some parts where we just don't have those answers, that's when we have to look at the will or the trust or again go into guardianship court. So we're really putting together a puzzle as far as how to put all this together.
So that's why it's important too to keep all your papers together.
It's helpful. Yep. But we'll usually find it.
Linda, our show goes so fast, and it was
It does.
great having you here, but we want to make sure there's 1,000 things to talk about and to get a hold of you about. Would you share your contact information with our audience, please?
Absolutely. So my office is in St. Charles, and my phone number is 630-377-3241. Again, that's 630-377-3241. And the website is StrohscheinLawGroup.com. I know Strohschein's a bit of a mouthful, but StrohscheinLawGroup.com.
Okay, very good, very good.
Thank you. And thanks for being our guest today, Linda.
Yes.
Thank you for
Good to
having
have
me.
you
This was
back.
fun.
So today our show was brought to you by Right at Home. The 4 pillars of right care from Right at Home mean that your loved ones cared for the right people. It's by the right people doing the right things for the right reason. Make the right choice today. Call us 877-353-3799.
I jinxed us last week because I tripped up on that very same
I don't know.
thing.
What is it?
And as I said, we're being videotaped, so make sure you watch us. It's the first one, so you can put this in the archives, okay? The website is Naperville, NapervilleSeniorCare.com. Look forward to seeing you there.
Don't touch that radio dial and stay tuned for the radio shopping show right here at WRMN 1410 AM. See you next week at 9:30 on Silver Solutions Radio.
See you next week, everybody.
Bye-bye.